I'm very pleased and honored to be able to introduce the Attorney General of the state of Washington, Bob Ferguson. Bob is the 18th Attorney General in Washington State's history. I was looking on your website this morning. We've only had 5 Attorney Generals since 1969.
That's true.
So there,
a lot of continuity there.
yeah,
It's true.
Well, a lot of long-term experience. As the state's chief legal officer, he directs 500 attorneys and 600 professional staff, providing legal services to the state agencies, the governor, and to the legislature. Bob got his JD from New York University Law School in 1995, but he also earned a BA in political science from the University.
The purple and gold. Yes.
Where he was also student body president. So, he confided in me that he knows it was a big mistake now. Bob's family are 4th generation Washingtonians. They homesteaded on the Skagit River. And I didn't know this. He's an enthusiastic mountain climber, backpacker, and birder. And also, I've read on your website that you're a grandmaster chess player.
Not quite. Internationally rated master in chess. Yeah. Yeah.
Well, anyway, without further ado, Bob Ferguson.
Thanks so much. Really appreciate it. Thanks. Thanks so much for the introduction, and good afternoon to everybody. Yeah, I'm definitely a diehard Husky. My mom and dad were Huskies. My little brother, though, is a Cougar and a diehard Cougar. Comes over every year for football games. So I have got the pin that you so kindly gave me. I've put it on, and I'll be snapping a picture and texting it to my brother right after I'm done. So we have a friendly rivalry, as you might suspect. Hey, it's an honor to be here, and I was here last year, which I really enjoyed, and I really appreciated being asked to come back. And before I get into my remarks, just a couple quick comments. One is Speaker Foley. Speaker Foley was, before he went into politics, worked in the AG's office for a short period of time. He was an assistant attorney general for a short period of time before he got into politics. And so we take great pride in our agency, of course, that Speaker Foley spent some time in the office attorney general. The office attorney general has a rich history, and Speaker Foley is obviously a very important part of that. And we're very proud of his connection to our office. We just came from Dayton. We've been doing a swing. I landed in Pullman the night before last, and then we went down to Asotin, Pomeroy, and Dayton yesterday, meeting with folks. So we woke up in Dayton this morning, and we had some meetings, and I was chatting with someone from the community there, and they were talking about how when downtown Dayton was really sort of transformed some years ago, they mentioned on their own how Speaker Tom Foley played a critical role in that, with some funding issues, as I understand it. So, his influence obviously spreads very wide, not just around the country, but especially right here in our state of Washington. So, so we appreciate his wonderful service to our state. So I'm going to talk about campaign finance, specifically around one case, a big case that's going on right now at the state of Washington. Before I do that, I just want to mention I'll take questions at the end. I'm happy to take questions on anything. Last year I spoke about the state and the federal government on several high-profile issues, including Hanford, including marriage equality, and want to make, and also marijuana, of course. And happy to take questions on those. In fact, I thought about giving a speech sort of updating on all 3 of those because there have been major developments. The governor and I had a press conference Monday about Hanford. We're back in litigation with the federal government. Marijuana. Significant changes around marijuana since I last spoke last year. Marriage equality, a lot's happened in the state of Washington around marriage equality as well. And so happy to take questions on those or frankly anything else that's going on in the state. Happy to do my best to answer questions. But I was asked and thought it might be interesting to chat about campaign finance. So a couple things. This is the first time I've done this slide presentation. So I've been kind of putting together on the road with my staff back in Olympia, and I'm not a high-tech guy, so we'll see how this works. So we'll give it our best shot. And before I do, day before yesterday, front page of the paper, court kills more limits to campaign contributions, right? That's the U.S. Supreme Court took action on certain campaign contributions, struck those down. I've not had a chance to read that decision yet. I believe it was a 5-4 decision, and had a chance to read some of the commentary around it, and happy to chat about how that might impact Washington State, the direction the state's, or the U.S. Supreme Court, excuse me, the direction the U.S. Supreme Court's going as it relates to campaign finance obviously has an impact for states, including Washington State. So happy to chat about that as well. But it's obviously in the news. What we're seeing in Washington State is not unusual, and I'm happy to take questions about it at the end. So we'll get started here, and I think I controlled this thing. So follow the money. And what we're going to do is do a case study. This is one case in Washington State. Want to be clear, we're in the trial court right now. I'll get to that later on. So it's an active case. That does limit a little bit what I can say about the case. Hope you understand that. But I'm able to talk a little bit about it. And this is a case of the state of Washington versus the GMA, the Grocery Manufacturers Association. And this case, it involves the largest concealment of campaign donations in state history. Okay? And by several $1 million. So it's a large, large case. And to get started, I'll go to a little background before we get to Washington. You really got to start in California to get a little background on this case. And so in California, this goes to the issue of genetically modified foods. And in 2012, Proposition 37, the Right to Know initiative in California, this was related to the initiative we later had in Washington State. And the Yes campaign, as you see, raised about $6 or $7 million. The No campaign raised $45 million. The reason I mention this is because those who supported that initiative encouraged boycotts of the brands who donated millions of dollars to the No campaign in California. Okay, so for those interests who donated to the No campaign, they were receiving some heat for their large out-of-state contributions to California to defeat that initiative. Now, before I go one step further, I want to make clear I took no position on the initiative we're going to talk about in Washington State. As the Attorney General, my job is to defend initiatives that are adopted by the people of the state of Washington. So I'm, for obvious reasons, careful about giving a public view in advance on any issues. So Initiative 522 is the mandatory labeling of genetically engineered foods, seeds, and seed products in the state. This was on our ballot in 2012. It was obviously heavily in the news, and the Grocery Manufacturers Association got involved in this campaign in a significant way. They're a trade association. They're based in Washington, D.C. They represent more than 300 food, beverage, and consumer product companies, and they were the largest single donor to the No campaign on No 522. Okay, and they contributed more than $11 million to the No campaign. Now, this is real brief. I just want to give you a sense of how things work in the state and how we handle campaign finance violations. We get a complaint. For example, a citizen can write and complain. The PDC, the Public Disclosure Commission, one of our clients, they handle investigations. We have lawyers in our office, in the AG's office. The PDC has investigators. They investigate. For cases, what's important here is for cases over $10,000, that's when it leaves the PDC's jurisdiction, so to speak. It's a larger case and comes over to the AG. The AG does have independent authority to file litigation, to initiate litigation for those who are violating campaign finance laws. In other words, much of my work is we have clients who make decisions about whether to file a lawsuit or not, right, or how to defend a lawsuit. When it comes to these types of cases, and the case that I eventually filed a lawsuit in, I do have independent authority to file these lawsuits. The AG does have that authority. The main point here is we have a close working relationship with the PDC, the Public Disclosure Commission, on the investigation and how we move forward on these cases. So from the PDC investigation, in December of 2012, the GMA had a communication that went out. And this is a document that's it's part of our complaint, so it's now part of the public record. There are some parts of the discovery process I can't talk about yet. And discovery is still ongoing. We're still seeking additional documents. But I'll give you a sense of what was going on sort of behind the scenes from the documents that we do have. So there was a communication that went out in December of 2012. Scope out a funding mechanism to address the GMO issue while better shielding individual companies from attack. So again, this is right after that California initiative, right? Our initiative is on the ballot in 2013. I think I might have said 2012 earlier. My apologies if I did. 2013, of course, is when it's on the ballot in Washington State. 2012 is when it's in California. So communication goes out. We want your donations, but we want to better shield individual companies from attack, the boycotts. Okay? So that's an internal document that was going on. They also want to prepare to fight Initiative 522 in Washington State. At that point, it was clear Washington State, there may be an initiative. In February 2013, they established what they called a Defense of Brand Strategic Account. Members were invoiced, and May through October, they contribute $11 million to the No campaign. So this, I'm going to try and do this, Vanessa, so let me know if I screw this up. So this is one of the ubiquitous ads, and I think if I just click on this, it might work. Let's see if this works. You saw lots of these ads, and this is my predecessor, Ken Eikenberry, great guy.
I've seen those actors in ads defending Initiative 522, and what they say is false. In fact, it specifically exempts meat and dairy products from being labeled. This misleading measure deserves a no vote.
I think you guys hear that okay? How do I get back to where I was? My apologies, Vanessa. So these ads were ubiquitous, right? Hey, that's campaigns, right? You get a message and you put it out there, and what's important from the state's perspective is that you do that in a way that plays by the rules. Okay? Thanks so much. Now, I'll come back to the lawsuit in a moment, but I want just to give a very brief history on campaign finance in Washington State. This is going to be very high level. I'm going to move through this pretty quickly. Just want to ground everybody a little bit in some key initiatives where the voters really weighed in on their views on campaign finance, their desire to have transparency in our elections here in Washington State. And that, of course, is what drives me as the attorney for the people in the state in moving forward. So going back to 1971, Democrats and Republicans, this was bipartisan, really wanted greater and tougher campaign finance disclosure laws. There was a coalition that was pulled together in 1972. They went to the ballot. They used the initiative process to propose Initiative 276, which the voters approved overwhelmingly, 72, 73, 74%, something like that. Also known as Washington Sunshine Laws. It did a couple things, again, at a high level. One, it created our Public Disclosure Commission. So what I was speaking about earlier, the work we do with the PDC, the Public Disclosure Commission, they were created as a result of that initiative. Create our first State Public Records Act. You want to know what your government's doing? You can do a public records request to me for documents. We turn them over, right? That's all from 1972. In 1992, there was another initiative dealing with certain campaign contribution limits and activities. Again, overwhelming support from voters, 73%. This initiative set some limits, restricted some campaign activities. So, for example, as a statewide official, 30 days before the legislative session starts, I cannot raise money. And through the legislative session, I cannot raise money, nor can the governor, nor can a state senator or state representative, called the legislative freeze. I can raise money again when the session's over. That was created through this initiative. So let's talk about current law briefly. And I'm not going to go into detail on this stuff, just want to give you a sense. We, of course, have limitations for statewide candidates, legislative candidates, in terms of how folks can donate to campaigns. There is not a limit for donations to initiatives. Okay? So folks can give very large amounts of money to initiatives. There are some rules around how you form, if you want to give to an initiative, how you form a political committee. You name your treasurer, you've got a timely report, that all goes to the PDC. You can log on to the PDC and see, okay, who's donating to this political action committee? Who are their donors? What's behind that PAC? And that's part of the transparency that's so important. So think about it this way. With donating to initiative, there are not limits. Therefore, the disclosure, the transparency is particularly important, right? That's important to people of the state of Washington. One other one that will be relevant to the case with GMA that you'll see in a little bit, that relatively recently the state legislature passed a law in response to a bit of a scandal around the state legislative race, saying that, hey, for PACs, you've got to have, when transferring to another PAC, you've got to have at least 10 Washington state donors who donate at least $10 each. You've got to have some local connection. There was a case, I won't go into details, in which sort of shell PACs were formed, money passed from one PAC to the next, to the next, to the next, to make it very difficult to figure out, well, where did the money come from? And the legislature wanted to make that a little bit more difficult, right? So, hey, each PAC, you've got to have 10 donors from Washington State who donate at least $10 each. You get a local connection. It makes it harder to create these shell PACs without any oversight or any scrutiny at all. Okay, very briefly, spending history. Here's governor's races. 1992, I think this is all contributions from all candidates, right? $7 million in 1992. As you can see in 2012, most recent race we had, $27 million. This is no surprise to any of you, right? We just want to show you a couple numbers. And then on initiatives, I want to give you a similar snapshot for initiatives in Washington State. And Washington State, of course, has a very robust initiative process. We've had it for a long time. We're a populous state. 1977, and we tried to pick some big initiatives that were fairly high profile. Spending for and spending against looks like $120,000 on that 1977 initiative. You get to 2011 and 2013, and the genetically modified foods, $10 million for it and $33 million against. So it's big time money, right? In our politics, it's big money. So let's go back now to our case. I gave you a little background on it. So on October 16th last year, I filed a lawsuit against the GMA, and we filed it just as folks were about to receive their ballots. Actually, that we received a complaint, we did some investigation. You saw those documents. We had some information, and just to be clear, what we saw, or what you would have seen up until that lawsuit, if you went on to the website, say, hey, who's donating to the No campaign, you'd have seen GMA having donated basically $11 million, just under GMA, just would have said GMA. Okay, well, was it just GMA, or were they getting money from their members putting that money together, pooling that together, and then sending it to the no campaign, right? That's essentially is the question, okay? So we allege that they solicited and received contributions and then made expenditures to oppose Initiative 522 without properly registering or reporting as a political committee. So PACs can make big donations, right? That's part of our system. You can form a PAC and ask folks to give money to it, disclose that, and make your donation. You can do that. That's all fair. But what you cannot do is solicit those funds, say we want to work against a certain initiative or for or against an initiative, seek those funds, pool them, and then just make a donation from GMA, right? Okay? You've got to identify who those individual members are if you're going to form that group for the purpose of engaging in a political campaign here in Washington State. Bottom line is, of course, we feel they concealed the true source of the contributions, which we'll get to in a little bit. Originally, this is sort of a detail we don't need to get into. Originally, it was $7 million we saw. Later on, we realized there's another $4 million that was added to an amended complaint later on. So that's our lawsuit, October 16, 2013. To GMA's credit, after we filed the lawsuit, they turned around virtually immediately. They did register with the PDC. They formed a PAC. They produced some information regarding their donors and contributions. And they came up with those 10 donors in Washington State at $10 each, which they had not done. Their donations now are up to $11 million. Here are some of the folks who donated. This came as a result of when they did disclose. So keep in mind, before the lawsuit, what you would have seen is GMA is giving $11 million, right? Once they disclose, now you have a fuller picture, right? Well, who's really funding that $11 million? So this is this handful of them, right? Pepsi Company, $2.4 million. Coca-Cola, General Mills. So we did amend the complaint. We realized there's additional $4 million, so it's now $11 million. And by several $1 million, as I want to emphasize, this is the largest amount of concealed money for a campaign in Washington State history. So it's a big, big case. I took out some slides just in the interest of time that sort of talk through some other large cases that the Washington State AG's office has been involved in when it comes to campaign finance. And hey, you know, the AG's office is an equal opportunity enforcer of our campaign finance laws. I think the State Democratic Party and the State Republican Party have been sued by the AG's office. Political interest groups on the left and on the right have been sued and paid heavy penalties. Okay, so I think I can say with some confidence that it doesn't matter whether you're a D or an R in the office. We take very seriously, each Attorney General, our campaign finance laws. The voters of our state, by the initiative process, our legislature, we've enacted some campaign finance laws, and people want transparency, and it's our job to enforce that. So I mentioned the allegations included the failure to create that PAC, identify those donors, and they also failed to include 10 donors in Washington State who would give $10 each. So here's what happened. While they did provide that information, they still are resisting our allegations in the following way. They filed a counterclaim and a new lawsuit against me personally. So that comes with the territory in these things. And what they are saying in a nutshell, I won't get in the weeds on the constitutional claims, but in a nutshell what they are saying is they're not saying, hey, we didn't break the law as you have it. What they're saying is those laws are unconstitutional, which makes this a big case, right? And which kind of gets back to the U.S. Supreme Court, right? We see all around the country, state courts, federal courts, up to the U.S. Supreme Courts, campaign finance laws ending up in our courtrooms, and some being struck down, right? Citizens United, McCain-Feingold. The case that just came out the day before yesterday, or yesterday rather. So this is happening, and so now they're challenging the constitutionality of some, what I would consider key provisions of our campaign finance laws, which makes this a significant case. Somewhat ironically, the lawyers for the GMA, it's a law firm I used to work for, so it's kind of one of those small world deals. So they have very good lawyers on their team, right? I mean, K&L Gates, they're some of the best attorneys in the state of Washington, and they've got resources to contest this.
Mr. Foley used to work for Preston Gates.
I think that might actually be right to bring it sort of full circle, right? So things you see from the slide here, right? They're claiming these are unconstitutional. And what's next? So we actually had a hearing originally scheduled for Friday, just a few days ago. So I'd hope to have some news on a key motion that they had. But just before, we've actually been before the court now for a period of time, but they decided to, they asked the judge to recuse themselves from the case. The judge declined. So what you can do in a case is you can affidavit a judge. Without a reason, you can one time say, we don't want that judge on the case, and not give a reason. Just say, we don't want that judge. So they did that. They affidavitted that judge. So we're now waiting to see who our next judge is going to be. So things have been slowed down just a little bit, but we think we'll be back on track with motions on this soon. This is just a thing, hey, PDC, you can search to get information on where things are going, where the money goes. It's a very user-friendly website to track to donations to Bob Ferguson, to Jay Inslee, to Rob McKenna, you name it. You can track it there on the PDC. So on the lawsuit in terms of going forward, then I'll take your questions on this or frankly anything else. It's always hard to know how these things will go, right? Because they're challenging the constitutionality of some of our key campaign finance laws, there's a lot at stake. There always is in any litigation, but I think it's fair to say there's a lot at stake at this one in particular. I feel very strongly, and I have to be a little careful in how I describe the case, but I feel very strongly that, number one, that in taking action on this case, that we're doing what AGs have done for a long, long time in this state, right? Defend and enforce our campaign finance laws to promote transparency in elections. That's number one. So there's, in some respects, nothing particularly unusual about this case, in the sense that the PDC, in small local elections where there's something going on, they're enforcing and levying fines, right? What's a little bit unusual about this one, of course, is the size, right? The scope, number one, $11 million. That's a lot of money by any standard. And number two, it's not too often where you actually sort of get to look behind the wall and see what the thinking is or what the communications are of an entity like GMA when they are effectively forming a PAC, whether they want to call it that or not, when they are soliciting donations to engage in a campaign here in Washington State. That email, for example, that says, hey, we're going to try and better shield you from public scrutiny. And they just put it out there in black and white, right? And that's not okay in my book, right? That's not okay. And my view is that we don't know what a court will ultimately do. This case could very well end up before our state Supreme Court, and who knows beyond. So it's one that could be in the court system for a while. But I really feel strongly that the scale and scope of the amount of money involved, combined with what I believe was a clear intent to evade the law, is a combination that requires litigation from the AG's office on behalf of the people of the state of Washington. So I'll be happy to come back perhaps in a year or two, or who knows how long this will proceed. But we're at the very early stages, and just to be clear, we're asking for discovery, more documents. So we don't even have the full picture yet. That's something that's very important to me to get. Hey, what's the full picture? Want additional documents, and we'll see how this goes. But it should really be a fascinating case, one to watch closely. And again, I'm happy to take any questions on GMA or on, frankly, Hanford, death penalty. And there's a lot in the news around issues as well around the state. Happy to take any of those questions also. Yes, sir.
Can I ask you a question about this particular case?
Yeah.
It struck me as you talked about intent. Why do you think that the Grocery Manufacturers Association did this? It couldn't be because they didn't understand the rules. They don't seem that complex to me.
Mm-hmm.
Do you think they did this strategically so they could challenge the constitutionality of the state laws?
I don't think that. No, I don't think there was. Hey, this is just me talking now, right? So first, I tend to try not to get in the heads of the other side, right? It's law and litigation, but no, I don't have some sense that they set about trying to challenge the constitutionality of our state laws. No. Do I think that they set about wanting to engage in opposing the initiative and do that in a way that better shielded their donors? You bet I do. They said so themselves. You bet I do. And I think that was a thoughtful approach in how they did that. We'll see on the constitutional arguments whether how the court views that. But as lawyers like to say, there are bad facts for them in this case. The amount of money and some of the documentation, those are bad facts for them. But no, I don't think they had some ulterior motive at the get-go in terms of challenging our state constitutional laws. No. Yes.
I'm a little confused on which constitution. Were they saying it violated state constitution, federal constitution, or both?
Both, yes. And so what they're saying in a nutshell is, like under the First Amendment, so take the 10 donors for $10 each requirement. That's a state law. What they're saying is that requires them to, in plain English, that forces them to associate with folks that they shouldn't have to associate with. They have to go get 10 folks who share their political views and donate to them before they can do that. Number two, they say they shouldn't have any limitations, right? It's speech. They should be able to donate as they see fit. And we were chatting earlier about the implications of the Supreme Court's decision of a day ago, and I've not read that decision, but in looking at the summaries and the articles about it, is a 5-4 decision, and And as I understand, what they were looking at in that case was they said you cannot have restrictions on donations. I think it's $132,000. Does that sound right, Mike?
46 something individuals, another 7.
Exactly. There's a cap total on how much you can give to all around the country, basically, right? And the feds put a cap on that. They're saying you can't put that cap on. If somebody wants to donate the maximum amount of money to every single person running for Congress, someone should be able to do that, is what they're saying. That's speech. That's free speech. And putting those limitations on it is unconstitutionally violates that free speech. The question that is left unanswered at this point, but I suspect will be asked relatively soon then is, we have limitations on how much someone can donate to my campaign, okay, or the governors or state legislators, right? At the state level, we have those limitations. We have them at the federal level as well. So while they don't address that specific issue, whether those limitations are appropriate or constitutional, it begs the question, right? If you're saying that overall maximum for all donations, right, you can't have a cap on that. Well, can you have a cap for an individual donation to one campaign? Or should someone be able to write me a check for $25,000 if they want, right? I think there's a good chance we're going to see litigation around that at some point. And that would get to potentially to how we handle in Washington State, right? That's a pretty significant part of how we handle campaign finance laws, those limitations, local candidates, state candidates, and they're obviously at the federal level as well. So while as I understand it, from the decision that came out yesterday, I do not believe, want to look at it again, that there's a direct impact immediately on Washington State campaign finance laws. That said, the reasoning, once I read the opinion, hey, the reasoning could lead to certain outcomes down the road, right, with the current makeup of the court. Yes?
I can see how ultimately down the road, if GMA wins, there could be something found unconstitutional. But if the state wins, what's the punishment? Is it a fine, or are they restricted from campaigning in Washington in the future, or how far does that go?
Thanks for asking that question. I probably should have included that. When I revise my slide presentation for the second time around, I'll include that. So in these cases, what often happens is the case is settled. Okay, there's an allegation by the AG against an entity. Things are filed, and they work out a settlement, okay, on how much the penalty will be, okay? And often that penalty is you're going to abide by our laws in the future, obviously, right? It is not that often that we actually, on a big case, end up before a judge, and the judge sets the penalty. Oh, that's ultimately we're going right now. We're before a judge. We're saying, Judge, they violated our laws, and once you find they violated those laws, if they do, the judge would set the penalty, okay? And there's a tremendous discretion, is what I can say, for a judge in setting that penalty. There are factors they look at, intent, for example, the amount of money that was concealed. So they've got factors they look at in setting that penalty. But to be fair, there's a lot of discretion placed in the judge in setting that penalty. I believe that, so to give you a sense of scale, in past cases, I think most of which were settlements. On some big cases, penalties have been as high as, say, $500,000, $600,000 penalties for entities that broke campaign finance laws. To be candid, do I think that's sufficient for this case? No, I don't. And I'm interested in seeing what a judge would have to say is the appropriate penalty. So, but in the end, that's from my standpoint, the ideal outcome is we defend the constitutionality of our state campaign finance laws, number one. Number two, they're found to have violated those laws. And number three, the judge sets the penalty on that. In an ideal world, that's what would happen.
Is it still possible to get a settlement, or is it too late for that?
Oh, no, there's always, in any litigation, settlement's always a possibility. That said, and I don't preclude that as a possibility. To be candid, I have signaled to my legal team that I want to see us just move forward on this. I want to see us move forward. That doesn't mean I'm going to not sell the case down the road. Any lawyer would never preclude that down the road, right? But this case is different in the respects I mentioned before, and I feel very strongly about it. But again, we'll see how that plays out. But no, it's like any litigation in the sense that you go through a lengthy court process. Hey, if we prevail at the trial court gives us a big award, GMA can appeal. You're now in the Court of Appeals. Go through that, then to the Supreme Court. So this thing could literally be years or it could settle tomorrow, right? Anything in between those two is entirely possible. Yes?
Could it be like a calculated risk for the GMA? Because it's not that the vote will change after being punished, and they could just kind of keep some collective money in their pocket to pay the fine.
Right.
And they still have what they want.
So good question. In other words, the question is essentially, hey, from GMA's standpoint, or anyone else who breaks the rules? Is it just the cost of doing business? Okay, right? That, hey, okay, we're going to break these laws. Yeah, we may get fined, right? It may cost us a few $100,000 before we're done. Maybe a little bit of bad publicity, but hey, we funneled millions of dollars into something, and it's worth that price of doing business. Again, I can't speculate on what they think as they go through this, right? What I can say, though, and I'm glad you asked that question, is that in thinking about a penalty for this case or what's the right way to resolve it, from my standpoint, I want it to be more than just the cost of doing business for them, right? That, in my view, the conduct was egregious, the amount of money was huge, and it's got to be more than the cost of doing business. So it's a message to the next entity, right, that is engaging in politics in Washington State, which they are entitled to do, just play by the rules, right? I've got no problem with that, right? In my campaign for Attorney General, an outside group spent $3 million on attack ads on me. Hey, you know, be a big boy. That's just the way it goes. If they play by the rules, if they're allowed to do that, tell my mom to turn off the TV for 3 weeks and, you know, and off you go, right? And that's how politics works. So you just got to play by the rules, right? You just got to play by the rules. So yes, my view is, in fact, I phrase it this way, it's got to be more than the cost of doing business, so that there is an appropriate penalty for them specifically, but also, to be candid and taking this action, you know that you hope it has an impact, a ripple effect as well. There were some who said, hey, Bob, you're filing this lawsuit right when people are getting their ballots, right? Is that appropriate even? And my view was, like, are you going to impact the election in some way because you're filing this lawsuit, you're holding a press conference? And my view was, hey, once I've got that information, we do an investigation, we have the information, we believe they're violating the law, it's my duty at that point to file that lawsuit. If I wait till election's over, well, maybe I've affected election by waiting, right? I mean, you get accused of it either way. My view was just play it straight. When once you've got the information, you feel you have a solid case, you feel you're right, that's when you file it. Not a day sooner and not a day later. But I think your question is a good one. I mean, there is that element to it. Is it just the cost of doing business? Yeah. Yes.
Do your arguments, do they turn on the fact that GMA's contributors were earmarking the funds for this particular ballot initiative? Or are you taking the position that that the Attorney General's office can compel membership rolls from any 501c nonprofit that contributes general treasury money to support or oppose a ballot initiative?
Good question. In fact, you hit on an important part in the whole lawsuit. General treasury dollars that folks have versus asking for money for a specific political purpose. Two very important, distinct things. So to answer your question directly, we are focused on the latter, that what they did was they sent out a communication saying we want to engage in this campaign in Washington State. We want to oppose this ballot initiative, right? We want to shield you from identity while we do that. Donate to us, and we'll put money into Washington State and shield you while we're doing it. What GMA says is, well, yeah, that was a part of the money we raised, we spent to Washington State, but there was some money, and this is a segregated account, so it's not part of their general fund, right? It's just a segregated account. They said, well, we kind of had a broader purpose of maybe opposing other initiatives as well. But the overwhelming amount of money that they did derive from this segregated fund was used in Washington State for that initiative, and we feel they were clear about what the purpose was. So Pepsi and Nestle, when they got that communication, we believe it's clear when they sent their $1 million over where that money was going, in large part.
One consequence of that, though, is that there's this loophole where potentially then GMA could say, all right, if we're not allowed to do that, we'll just fundraise in a general, broad sense across the whole country, and then,
and use our general funds.
Membership rolls, which the Supreme Court would probably not.
And so that is possible. I want to be a little careful here because now we're kind of in some details of the case, but this is an important point. So yes, if you have a general fund account, right, you can use that. And then it comes from GMA, right, or an entity, right? It's just a general fund that you have for multiple purposes. But I don't think it's as easy as saying, hey, they can just get around it that way, because I think what made this effective for them was there was an initiative, it was on the ballot, it was in Washington State, had a chance of passing. Hey, donate to us so we can oppose that, right? It's pretty hard to sort of work around that. If that's something that's going on, it's on the ballot, it's coming in a year. Could they have used their general funds? They could have, but they chose to sort of go this route, and I don't tend to understand the reasons for why they chose that route. But while there is a difference, I'm not sure I want to describe it as a loophole necessarily, right? There are sort of rules in how you do it. The key thing, though, is that once you solicit folks for a specific political purpose, right, you've then got to form that pact. You've got to disclose those donors. And hey, when it comes to our campaign finance laws more generally, look, they're complicated, and finding that perfect balance is never easy in anything in life, right? And I suspect campaign finance laws are no different. But we feel in Washington State we have a pretty good system that's worked pretty well in terms of providing that disclosure for folks. Yeah.
In this Hanford case, what is the state of Washington trying to get the feds to do?
In the Hanford case?
Yeah.
Sure.
That I'm clear.
Sure, be happy to. Well, it's complicated is why. I mean, it's so Hanford. Let me just give a little background. Then I'll talk about what happened on Monday. So, with Hanford, as you know, right, high-level nuclear waste stored there, posing public safety and health risks to people of the state and to our environment. As you know, if you've ever done a tour of Hanford, which you haven't, there's public tours of Hanford. Really encourage you to do it sometime. If you haven't done it, you get a sense you are right on the river, right? You are right on the river. That I guess I know that from reading it, but once you go there and see it, like, whoa, it gives you a different appreciation and the size and scope of the operation as well, I might add. So a number of years ago, the state entered into a tri-party agreement with the feds around Hanford and the cleanup of Hanford and setting deadlines for the cleanup of Hanford. So the Department of Energy, for example, was involved in that, the tri-party agreement. A few years ago, when Rob McKenna was Attorney General, he sued the federal government, Department of Energy, for not meeting those obligations, speaking at a high level now, right? That lawsuit, so that was a lawsuit in the Eastern District of Washington, federal court, Eastern District of Washington, Judge Van Sickle, and go before the judge. The parties work out an agreement called the consent decree. So a consent decree was approved by the federal court. So I really emphasize that because these aren't just like handshake deals with the federal government, right? These are agreements as a result of a lawsuit that the federal court said, yep, that's how we're going to handle this thing, okay? And that laid out very specific deadlines for cleanup of Hanford and disposing of the nuclear waste, treating the nuclear waste, building a waste treatment plant, the vitrification of the waste, all that sort of thing. And that was 2 years ago, essentially. In those last 2 years, 2.5 years, and I've been AG for just a little bit over a year, just from what I've seen is as it became clear that one deadline was missed and upcoming deadlines, nobody disputes that upcoming deadlines will be missed. A large number of them coming up for being on schedule for the cleanup. The feds don't dispute that. And what we've been asking from the federal government, again at a high level, is, hey, what's your plan to stay on schedule? What's the plan here? And by plan, we don't mean, hey, you give us a call and you chat with us over the phone about it, or you come to a meeting and give us a sense of it. A plan, it's a written plan. We want something in writing that's very specific and detailed. And to be perfectly candid, they simply did not provide it to us. They just did not. And we had a meeting, myself and the governor and Secretary Moniz from the Department of Energy. He came out. We had a good conversation a few weeks ago. But it was still that high-level conversation, concepts, not a specific plan for how to move forward and address the challenges we have there. So what we announced Monday was we are now using the legal tools we have under that consent decree. That settlement gave the state certain legal tools if we were unsatisfied with how things were progressing on the cleanup of Hanford. And so what we've done is we have sent a proposal, which is essentially an amendment to that consent decree, laying out maintaining our ultimate deadlines for cleanup of Hanford, but setting some shorter-term deadlines to get them back on track. Okay, moving, for example, we have a lot of waste in single-shell tanks that, as you read about on a regular basis, are leaking and pose, in our view, serious environmental risk and public safety risks. While they are trying to build this waste treatment plant, let's get that waste in these single-shell tanks that are years past their useful life, right? Put them in double-shell tanks, construct double-shell tanks to put that waste while it's waiting to be treated through a waste treatment plant process. So we put a specific proposal before the federal government. They, as a result of what we're doing, send one to us as well. What happens now is there's a period of a month or two where, under the consent decree, lays out the process, where the feds and the state can have a conversation about our respective proposals. If we can agree, great. We go to the court, and the court hopefully approves that. If not, if we do not get agreement, and to be candid, I think we're a long way from any agreement right now, we then would go to, we have the option, the state has the option of going to the federal court, back to Judge Van Sickle and saying, hey, we've gone through this process, we've had our conversations, our effort to try and resolve it, we can't do it, we're back before you, Judge. Make the federal government accept our request for how to move forward on the cleanup of Hanford. So at a very high level, that's where we're at and where we're going. And this is one of those issues where Chris Gregoire is AG, Rob McKenna is AG, now myself as AG, and governors have been very involved. I have no doubt that you'll have an AG here in 15 years talking about Hanford, right? And the challenges there. Those deadlines are, from the consent decree, are out. The ultimate deadlines for cleanup, we're talking 2040, 2047. I mean, it's a long-range plan. That waste is, it's a big, big job to get that cleaned up, and it'll take a long time. But from my standpoint, saying we don't have we the feds, saying we the feds don't have the resources, right? We've got budget problems. We've got problems from a technology standpoint. Those aren't going to cut it, right? We have a deal. It's a deal approved by a federal court as a result of a federal lawsuit, and they've got to live up to that. And to be perfectly candid, I don't feel I've seen the level of commitment from the federal government that, frankly, as a Washingtonian, right, let alone as the Attorney General, as a Washingtonian, that I would expect, given, hey, the sacrifice our state made, right, for the World War II effort, the Manhattan Project, right? Hey, it was here in our backyard, and we helped out when the country needed it. Hey, it's fair is fair, right? We need the federal government, I think, to step up its game. One more thing, it's a long answer to your question, my apologies, but one more thing I'll also just mention on that is there's a lot of conversation about Yucca Mountain and the high-level radioactive waste ultimately going to Yucca Mountain. There's been a lot of political moves around that. Obviously, Henry Reid in the Senate, senator from Nevada, has been heavily involved in holding up Yucca Mountain, which is located in Nevada, being the repository for that nuclear waste. Yucca Mountain was chosen through a lengthy political process through Congress, and the administration, the Obama administration, has, to be candid, slowed that down, right? So the state of Washington a few years ago actually sued the administration, saying, hey, the administration can't simply, the executive branch can't simply stop what's already been approved as a policy by the Congress. And so long as you've got money in your account, you've got to move forward with permitting and doing all that with Yucca Mountain. So we sued. South Carolina, I think, was involved as well. They have waste there. Some other plaintiffs were involved. That's been working its way through the courts. One of our attorneys, Andy Fitz, was selected to give the oral argument before the D.C. Court of Appeals. Quite an honor, actually. Our lawyers are very, very good when it comes to Hanford. Andy argued that about a year ago, and we got our decision from the D.C. Court of Appeals, a strong decision a couple months ago saying we were right, that the executive branch can't simply stop doing something that the policy's in place and it's been budgeted. You've got to move forward if you've got the budgeting for it, if you've got dollars in your account. So we won a big one there. That said, ultimately, when it comes to Yucca Mountain, there's a political fight going on, right? And I'm just a lawyer right here in Washington State. So what I choose to do is use the law, the tools that I have under the law to represent the people of the state of Washington and try and move forward on Yucca Mountain and the cleanup of Hanford. But I say that understanding there are other dynamics that go on that obviously impact both those things. Yeah.
But can you predict inaction at the federal government level just because they can? I mean, is that what you've seen with Yucca Mountain? Is that what you've seen in your direct suit with the Department of Energy with appropriating cleanup dollars for Hanford is delay tactics? And what mechanism do the federal courts have to truly enforce a decision if the federal government just chooses to do nothing?
Right. So good question. So the federal courts, let's put it this way, that nobody wants to have a federal court sanction them or assess penalties, right? Nobody wants that. And but federal courts have that power, right? It doesn't matter if you're the federal government, right? A federal court can say, hey, you know what? You're in violation of this consent decree. You're paying a fine, or you're in contempt, and do X, Y, and Z. And this may be a bad analogy. The governor actually mentioned this on Monday, so I'm not sure if it's good or bad analogy, but he mentioned, but it's one that's at least useful to think about, is that in Washington State, the McCleary decision on education, right? You've got a court saying to the legislature, hey, in order to follow our constitutional mandate of funding education, right? Top priority in our Constitution, funding education. The court stepped in and said, you're violating that. You've got specific dollar amounts they're plugging in there. I think that's resulted in some action from the legislature as a result of that, right? And people wonder, hey, what can the court really do with McCleary? Are they going to put legislators in jail? Can they fine them? Can they sanction them? What's the penalty? Those are some uncharted territories, but the bottom line is nobody wants to get crosswise with the court, either your state Supreme Court or a U.S. federal district court, right? So there is that potential hammer out there, right? And I don't choose lightly the idea of litigating, going back into court and getting in front of a judge. That said, after a couple of years of what I see as too much inaction, okay, too little of a commitment when it comes to Hanford, that I felt, and the governor obviously felt as well, my client, that we needed to use our legal tools. And again, we don't do that lightly. We understand, hey, a fight with the federal government, that's, you know what you're in for with that. But we just felt that was our best option at this point. Yeah. I think we have time for another question or two, maybe? One more? Okay. You haven't had one yet, so go right ahead.
Can you do updates on the marijuana law?
Sure. So I've got maybe just enough time to updates on the marijuana law. So on marijuana, happy to chat afterwards for a couple minutes as well, if you like, because it's a big topic. Voters obviously approved the legalization of marijuana a little over a year ago. Obviously, the federal law is in direct conflict with state law on that. The state of Colorado also approved the legalization of marijuana. So from a legal standpoint, the issue of the legalization of marijuana raises very complex legal issues, and very challenging ones for our clients. Think about it. Our clients include state troopers who might be pulling someone over who may possess marijuana. If they take that marijuana in possession, are they somehow now, as a state employee, violation of federal law? What does that mean? You're a state university. You get federal grants. How do you handle students on campus with marijuana? You don't want to get crossfires with the federal government and lose federal grant money. On the other hand, you got a new state law that says it's legal. How do you handle that issue? I mean, it's a myriad of legal issues on that are very challenging. We give legal advice to the State Liquor Control Board as they set up a regulatory system for it. So taking a step back, my job as AG is to defend the will of the voters. Voters approve that through the initiative process. Our job as the attorneys for all of you is to defend the will of the voters. That's job one. Shortly after getting elected, I went back to Washington, D.C. to meet with the U.S. Attorney General Eric Holder. The purpose of that meeting, really primarily with myself and Governor Inslee, was to communicate directly to Eric Holder. Remember, back then, folks thought, hey, is the federal government going to kind of crack down on Washington State, prevent us from moving forward? And that was a very real question. And my message to him was a simple one, similar to Hanford in the way that, hey, we're not looking for a lawsuit here. But to be clear, I'm going to defend the will of the voters, and we've got a legal team in place, and if you come looking for a fight, we'll be prepared, okay? But let's try and find a way to avoid that. And to Eric Holder's great credit, he took his time with that throughout that process. I was often asked, hey, Bob, don't you want them to hurry up and make a faster decision? My response is always the same. Hey, I'm glad they're taking their time. It's a complicated question, right? And as you know, they came up late last year with a letter that's allowing Washington, Colorado to move forward, but outlines 8 areas of concern. I'm not sure if that's the word they use in the letter, but 8 areas of concern. For example, making sure marijuana is not in the hands of minors, right? Making sure that marijuana stays within the borders of Washington State. The governor and I have worked closely with the U.S. attorneys, U.S. Attorney Ormsby and Jenny Durkin, the Western District of Washington, to work through those 8 areas of concern. We share those. We agree with them. And so there's regular communication with us and the federal government on how we are trying to build a system that is consistent with those 8 areas of concern and also consistent with the initiative itself. Where my office has gotten involved, most specifically at a higher publicity level, is a big question that was left unanswered by our initiative was, can local jurisdictions, cities, counties, can they opt out in the sense of forbidding businesses from selling marijuana? You can't forbid someone from possessing. It's still legal to have it. But can you say, no, we're not going to have any businesses selling marijuana? Can local jurisdictions do that? In Colorado, the initiative was actually quite clear. You could opt out. It's like Colorado Springs, no marijuana being sold in Colorado Springs. They opted out. But the question was, what about Washington State? So we were asked for a formal opinion by the State Liquor Control Board. So I don't go running around issuing opinions. Someone's got to ask under certain rules, and then we issue them, right? So we were asked, so we did a formal opinion, which is the opinion of our office. Not binding on a court, but courts give them deference, as you might imagine. So we were asked that very question. Hey, can the city of Pullman, can the county of Spokane County or King County opt out effectively? And in looking at that at a high level, under our state laws and constitution, local jurisdictions are given great deference to set ordinances as they see appropriate, to set their laws as they see appropriate, which makes sense, right? It's local jurisdictions. Unless, and it's an important unless the state preempts them, okay? Unless the state more specifically says, you local jurisdictions must do X or you cannot do Y. And it's got to be very clear, okay? It's got to be very clear that the state is saying, local jurisdictions, you cannot do X or you must do Y. So in looking at the initiative, the question was, did the initiative say that jurisdictions must sell marijuana, provide for the sale of marijuana? Was that contemplated by the initiative? Can't just be what people sort of thought as they voted. What's the language of the initiative? So in looking at that, nowhere in the initiative does it say, hey, local jurisdictions, you must provide for the sale of marijuana. Now, when our opinion came out, those who wrote it said, well, wait a second. We said in our initiative, we set maximum numbers for jurisdictions, the maximum number of businesses. I said, well, that's true, but you did not set a minimum. Your minimum can be 2, it can be 1, it can be 0, right? And I want to be clear, had the initiative said at least 1 and no more than X, well, okay, at least 1. That's very clear. The state is then saying through the initiative process, you must have at least 1. Then you must follow that. But in the absence of that specific language, I feel that our state Supreme Court has been clear where in the absence of that, local jurisdictions have the authority to do what they want. Now, I say all that very mindful that there are policy implications from that decision, okay? If you have some jurisdictions around the state that opt out and some that opt in, and you've got this patchwork effect going on, there are pros and cons to that from a policy standpoint. I'm very mindful of that, and I think I understand those. That said, when I'm asked as a lawyer for the people to give a legal opinion, I don't consider those policy considerations. It's not my job. We have a legislature. That's their job. My job is, hey, what's the legal analysis here, Bob? Right? What's the court going to say? And that's what I do. So the legislature can, in fact, there was an effort in this last session to do this. They can change the law to require local jurisdictions to sell marijuana. They can do that. They can do that. I think there was a bill this last session to do exactly that. They could try again next year. In fact, I think there's some fair amount of support for it, actually. Is that my legislative guy wasn't so sure. But the legislature can do that at any time, actually change that from a policy standpoint. My opinion was really that it's a legal opinion, legal analysis. Last thing I'll say before I wrap up is that that is not binding on a court. I have little doubt that ultimately we'll see this decision, this issue decided by a court in the following way. A local jurisdiction says, no, you can't sell marijuana. A local business owner says, hey, I want to sell marijuana. I've got a license from Liquor Control Board, and sues that local government, okay, saying you've got to let me sell marijuana. The state would unlikely be a party to that lawsuit, right? Business owner versus local jurisdiction. It's possible we'd get involved in some way, but I think ultimately we'll see that litigation, and they'll be decided by a trial court, no doubt work its way up to our state Supreme Court, and you can see if I got it right in my opinion or not when that time comes. So I'll wrap up there and just want to conclude by saying thanks so much for your time and your questions and your interest. Last thing I just will say is that, in my office, when I talk to my team of attorneys and staff, the most important quality I want in our team, aside from obviously giving good legal advice to our clients, and that's our job, but the quality I most want is independence in the work that we do. Because, and this is a good example, right, that in giving advice to our clients or representing the people, it's really critical that they believe that the work I do or the legal advice I give is not based on my party affiliation. I happen to be a Democrat, my party affiliation, or who my donors are or who aren't my donors. It's based on the law, and we go where the law goes, right? That's our North Star. And that's critically important, because if you ever lose that trust with the people or your clients, right, if there are folks from the other political party who are my clients, which they are, right, the legislature is, or plenty of folks of the other party, if they believe the advice they're getting from me on all sorts of issues they're dealing with day-to-day in legislature is somehow guided by something other than the law, that's a bad place to be, and the system really breaks down. So the quality I most want in our team is that independence. So folks really feel we follow the law all the time. Hey, that may mean I'm making some decisions that make my friends very unhappy, and trust me, there's not a week goes by where that doesn't happen, right? But my view is that just means I'm doing my job, right? You go where the law is, and I think if we do that, and I think our office has, for the most part, Office Attorney General has had a strong history of that, and it's something I really value and I'm trying to uphold. Thanks a lot for your time, and go Cougs.